We'll be looking at part 3 of Federalist 83. We'll start with paragraph 9. Please take a look at or listen to Federalist 83 part 1. I gave you an introduction on this. This is going to be a long one. I also said that I'll be showing you the books that we've talked about, the books that I've found helpful over the years, and I want to show them to you and say, when you have time and you decide you want to study the Federalist Papers and the founding era a little better, these books would be helpful. One of them is this book, Fame and the Founding Fathers. It's a collection of essays by Douglas Adair. It's published for the Institute of Early American History and Culture at Williamsburg by W.W. Norton. But it's a collection of essays. It just kind of gives you a taste of what people like Madison, Hamilton, Jefferson, Washington, John Adams, some of these important founders were thinking about the idea of fame. It's not in a sense that we use it these days. They were wanting to leave a name behind that would be talked about for generations to come all over the world. And they knew that they were doing something important when they were writing the Constitution and founding this nation. I've mentioned it before. They are, just like most human beings, full of faults, yet they did great things at that time. So let me start reading paragraph 9. Start with paragraph 9. These examples might be sufficient to elucidate the maxims which have been mentioned and designate the manner in which they should be used, but that there may be no possibility of misapprehension upon this subject, I shall add one case more to demonstrate the proper use of these maxims and the abuse which has been made of them. Basically, Hamilton says that just because we haven't talked about trial by jury in civil cases, our opponents are attacking us and saying that we're going to do away with trial by jury in all cases, and they're spreading the lies and half-truths about us just like they have been in the past, just on all the papers here in the state of New York. And he says, well, we know, I've already talked to you about part of these statements being lies and half-truths, but every once in a while they say something that merits attention, that deserves that we actually talk about it. And that's what he's doing here. He continues in the next paragraph. Let us suppose that by the laws of this state, a married woman was incapable of conveying her state, and that the legislature, considering this as an evil, should enact that she might dispose of her property by deed executed in the presence of a magistrate. In such a case, there can be no doubt but the specification would amount to an exclusion of any other mode of conveyance, because the woman, having no previous power to alienate her property, the specification determines the particular mode which she is for that purpose to avail herself of. But let us further suppose that in a subsequent part of the same act, it should be declared that no woman should dispose of any state of a determinate value without the consent of 3 of her nearest relations, signified by their signing the deed. Could it be inferred from this regulation that a married woman might not procure the approbation of her relations to a deed for conveying property of inferior value. The position is too absurd to merit a refutation, and yet this is precisely the position which those must establish who contend that the trial by juries in civil cases is abolished because it is expressly provided in cases of a criminal nature. See, don't so much worry about what this paragraph says in detail, because it's a little legalistic in one part. But basically what he's trying to convey to us, tell us, is that look at all the cases that might come up under civil law, under civil cases. It has so many variations that if we were to write one law in the federal Constitution, then what about the next case? What about the next case? What about the next case? So thousands of cases arise. That's why we have decided to leave it to the national legislature to decide on what cases merit jury trial in civil cases. Because it says just the case that we talked about above could be in hundreds of different forms and shapes. Cases like this will just be, there will be so many of them, so many variations, that it would be crazy to put every single one of them in the Constitution. So we are not abolishing trial by jury in all civil cases. We're leaving it to the state, to the national legislature to decide. From these observations, it must appear unquestionably true that trial by jury is in no case abolished by the proposed Constitution, and it is equally true that in those controversies between individuals in which the great body of the people are likely to be interested, that institution will remain precisely in the same situation in which it is placed by the state constitutions, and will be in no degree altered or influenced by the adoption of the plan under consideration. The foundation of this assertion is that the national judiciary will have no cognizance of them, and of course they will remain determinable as heretofore by the state courts only, and in the manner which the state constitutions and laws prescribe. All land causes, except where claims under the grant of different states come into question, and all other controversies between the citizens of the same states, unless where they depend upon positive violations of the Articles of the Union by acts of the state legislatures, will belong exclusively to the jurisdiction of the state tribunals. Add to this that admiralty causes and almost all those which are of equity jurisdiction are determinable under our own government without the intervention of a jury. And the inference from the whole will be that this institution, as it exists with us at present, cannot possibly be affected to any great extent by the proposed alteration in our system of government. So it says in this new Constitution, with the exception of a handful of things, all these other cases that might come up are left to be dealt with in the hands of the state constitutions. So he says all these accusations are wrong. They're half-truths. The next paragraph, the friends and adversaries of the plan of the convention, if they agree in nothing else, concur at least in the value they set upon the trial by jury. Everybody knows that trial by jury is important. Or if there is any difference between them, it consists in this: the former regarded as a valuable safeguard to liberty, the latter represented as the very palladium of free government. For my own part, the more the operation of the institution has fallen under my observation, the more reason I have discovered for holding it in high estimation. And it would be altogether superfluous to examine to what extent it deserves to be esteemed useful or essential in a representative republic, or how much more merit it may be entitled to as a defense against the oppressions of an hereditary monarch than as a barrier to the tyranny of popular magistrates in popular governments. Discussions of this kind would be more curious than beneficial, as all are satisfied of the utility of the institution and of its friendly aspect to liberty. But I must acknowledge that I cannot readily discern this inseparable connection between the existence of liberty and the trial by jury in civil cases. Arbitrary impeachments, arbitrary methods of prosecuting pretended offenses, and arbitrary punishments upon arbitrary convictions have ever appeared to me to be the great engines of judicial despotism, and these have all relations to criminal proceedings. The trial by jury in criminal cases, aided by the Habeas Corpus Act, seems therefore to be alone concerned in the question, and both of these are provided for in the most ample manner in the plan of the convention. So, see, Hamilton here is trying to wiggle out of a very important thing. And like I said in Federalist Paper, in part 1 of this Federalist, he's tired by this time. He's tired of being attacked. He knows that he's done with this project, and he just wants to kind of brush some of the important things aside. And as you remember, when I said in Federalist 78 that when they wrote the Bill of Rights, half of those 10 amendments have to do with judiciary. So Hamilton was really trying to say some of the really important things that people were concerned about were not as important as he thought they should be. And he realized, no, people are wanting trial by jury, are wanting a Bill of Rights, written Bill of Rights. So we'll come back and continue part 4 of Federalist 83.